Welcome to the Idaho Debates, a look at the candidates on the primary ballot for the Idaho Supreme Court. The Idaho Debates is a collaborative project of the Idaho Press Club, the League of Women Voters of Idaho, Boise State University's School of Public Service, and Idaho Public Television. The Idaho Debates are brought to you by contributions to the Idaho Public Television Endowment.
Hello and welcome to the Idaho Debates live from the Idaho Public Television studios in Boise. This is our first and only debate of the primary season, but it's a good one. And it's the only televised debate with all four candidates vying to be the state's next Supreme Court justice. A Supreme Court justice in Idaho is one of 5 people who work as the ultimate and final legal authority in the state. They have the last say in Idaho legal matters and work as administrators of the entire court system. Their duties are primarily the execution of fair, impartial deliberation and rulings on some of the most difficult legal questions in the state, protecting equal access to justice and protecting the constitutional rights of the people of Idaho. Tonight, we welcome the 4 individuals who are asking for your vote. Robyn Brody has practiced law in the Magic Valley for 20 years. She has served as the president of the 5th District Bar Association and the Idaho Trial Lawyers Association. She graduated from the University of Denver College of Law and is a solo practitioner at Brody Law Office. Clive Strong has worked in the Idaho Attorney General's office since 1983. He is currently the chief of the Natural Resources Division. He has argued 2 cases before the United States Supreme Court and numerous cases before the Idaho Supreme Court. He graduated from the University of Idaho Law School. Curt McKenzie graduated from Georgetown University Law Center. He worked 1 year in the Ada County Prosecuting Attorney's Office and 6 years in civil litigation at Stoll Reeves before opening McKenzie Law Office. He served 7 terms in the Idaho State Senate, was on the Public Defense Reform Interim Committee, and was the president of the Pacific Northwest Economic Region. Sergio Gutierrez has served as a district judge and administrative district judge and now serves on the Idaho Court of Appeals. He was chairman of the Idaho Supreme Court Fairness and Equality Committee and co-chair of the Judicial Recruitment Committee. He graduated from the University of California Hastings Law School and has served in the judicial branch since 1993. Also on stage with me is our panel of reporters selected by the Idaho Press Club. They'll ask the candidates questions tonight, and these 3 don't need nearly as long of an introduction. Betsy Russell of the Spokesman Review, Rebecca Boone of the Associated Press, and Bill Denser of the Idaho Statesman. I'm Melissa Davlin, co-host of Idaho Reports here on Idaho Public Television. I'm moderating tonight's debate and will do my best to make sure all candidates get equal time and stay on point. To remind the candidates how long they've been talking is Eleanor Chahey, volunteer timekeeper from the League of Women Voters. We've asked the candidates to engage each other on the issues. In other words, less emphasis on a rigid format and more focus on an intelligent discussion that helps you, the voter, cast a more informed ballot. Each candidate will be given 1 minute for opening comments and 1 minute for close. We drew straws a few minutes ago to see who would go first, and Robyn Brody, that honor goes to you.
Thank you. The Constitution guarantees our rights on paper, but without a legal system to actually enforce those rights, well, the rights don't mean anything. I'm running for the Idaho Supreme Court because I believe that our system of justice is supposed to serve and protect people, all people. We need a Supreme Court justice who not only has great knowledge and understanding of the laws of the state of Idaho, but who's also connected to the people who are affected by the decisions that are made. I've spent my entire career dedicated to providing people with access to the law. I represent this widow who comes in needing help getting her marriage license from Salt Lake City, farmers, ranchers, our local school district, our local hospital. Those are the types of people that I represent. I have never been afraid to climb in the foxhole with the people of the state of Idaho, and I'm asking for your support on May 17th.
All right, thank you so much. And the next opening comment comes from Clive Strong.
I want to thank Public Television for giving me this opportunity to speak to Idaho voters. Since Attorney General Jim Jones hired me in 1983, I've had the opportunity to serve the people of Idaho for the last 33 years. My duty is to defend the Constitution and advance the rule of law without consideration of any political or special interest. I've been recognized at the state and national level for resolving complex, decade-old conflicts that have divided Idahoans. I was responsible for drafting the Swan Falls Settlement Agreement that brought a resolution to a conflict that extended back into the 1920s over the allocation of water in the Snake River Basin I was responsible for the Snake River Basin adjudication, which was commenced in 1987 and completed in 2014, adjudicating 158,000 water rights, the largest civil case ever executed in the state of Idaho. I've represented the state of Idaho in every major natural resource settlement for the past 30 years. I've twice defended the state of Idaho's sovereignty before the United States Supreme Court, and I increased revenue to public schools by enforcing the Constitution and drafting legislation to modernize investing. I have the trust and confidence of a broad range of people, and I have a proven leader, and I would like the opportunity to continue to serve as part of the Idaho Supreme Court.
Your time is up. Senator McKenzie, you're up next.
Thank you. I'm Curt McKenzie. Many of you may know me from my service in the state legislature. Fewer know that I'm the third generation in my family to go to NNU in Nampa. And in fact, all three of my brothers went there as well. After I graduated from NNU, I was offered a full tuition scholarship to Georgetown University's Law Center. I graduated there in the top 10% of my class. Since then, I was admitted to the bars of Maryland, Washington, D.C., and then Idaho. I've had a very diverse legal practice. I've worked with large law firms. I've worked with the state as a prosecutor. I've taken over 20 jury trials to verdict, and I've had my own practice. In addition to that, I've had a long record of public service. I bring a unique background to the candidates for the court. I've got a strong academic foundation, a diverse legal practice, and a long record of public service. Thank you.
All right, and Judge Gutierrez, the next opening comments from you.
Thank you, and thank you those in TV audience that have welcomed us into your room, into your homes. I am the senior judge of the Court of Appeals with 14 years of appellate judge experience. I sometimes overlook the fact that I was a lawyer once before too. And so as a public interest lawyer, working also for a private firm, and eventually operating a solo practice. I appeared in our state trial courts, in our federal district court, before the Ninth Circuit, and also before the Board of Immigration Appeals. I believe I have accumulated the experience to be able to make the transition from the floor, the first floor at the Court of Appeals, and ready to take the position of Chief of Justice with the Supreme Court. Thank you.
All right, thank you so much. And the first question is going to come from Betsy Russell for Senator McKenzie.
The Idaho Code of Judicial Conduct places restrictions on how candidates for judge can campaign. My question is about how you interpret these restrictions and how you're approaching this campaign. Senator McKenzie, you have campaigned almost entirely to Republican voters, appearing at Idaho Republican Party Lincoln Day events and seeking out endorsements from your fellow Republican legislators. You've characterized your Lincoln Day appearances as meeting with voters. Why are you appealing only to Republican voters when you're running for a nonpartisan position on the Idaho Supreme Court?
Thank you, and I'll talk about that tomorrow night when I'm meeting with the Bonneville County Democrats. The organizations that support me, in addition to my colleagues in the legislature, include nonpartisan organizations. The Professional Firefighters of Idaho have supported me not only for my work in getting certain on-the-job cancers covered, but also protecting their right for collective bargaining. The Fraternal Order of Police, which is the largest organization of police members in the state, endorsed me for my work protecting our frontline officers. Farm Bureau as well. And so these are nonpartisan organizations that have supported our candidacy, and I appreciate their support.
All right, the next question is for Robyn Brody.
Mrs. Brody, you've also accepted high-profile endorsements, including from Twin Falls County Prosecutor Grant Lobes, who is an active Idaho Republican Party official. How are you balancing the need for nonpartisanship as you campaign for this position?
You bet. You know, Betsy, I've looked all over the state to all kinds of different organizations and people. Grant has been a longtime friend. and someone, a colleague with whom I've had a terrific relationship over the years. But you know, beyond that, I've been to various parts of the state. I've addressed Democrats, Republicans, independents. Basically, in this kind of race, I'll talk to anyone who will give me a minute and an ear to listen.
The next question is for Clive Strong.
Mr. Strong, while Senator McKenzie has drawn some criticism for soliciting endorsements from Republicans and interest groups, you've also amassed high-profile endorsements, including one from the current Speaker of the House. Why have you done this, and could it lead to any conflicts of interest if you're elected to the court?
The reason I've collected all of these endorsements is it was a reflection on my work. When I joined the Office of the Attorney General, I intentionally accepted a policy of not being a partisan politician. I've been nonpartisan throughout the 33 years that I've been with the Idaho Attorney General's office. I've done so because I think it's important that in advising the legislature that both the Republicans and Democrats can feel confident that I'm giving them impartial advice. And so the purpose of my endorsements was to demonstrate that throughout my experience that I have been able to maintain that nonpartisan position and gain the confidence and trust of many people on both sides of the aisle.
You know, the next question
Okay.
goes to you, so you can comment in
All right.
your answer if you'd
Okay,
like.
thank you.
from
Okay,
Betsy.
Judge Gutierrez, you have not been public about promoting endorsements. Why not? And how should voters judge whether you are the candidate they would choose?
Yeah, I think we need to be careful so that we don't run afoul of the judicial canons of ethics that intentionally provide for our races to be nonpartisan. And I think we run into problems when both candidates and the media begin to portray us as politicians. We are not running for political office. We're running for an elected judicial office. In Williams, Yulee versus Florida Bar, the U.S. Supreme Court made this statement: judges are not politicians, even when they come to the bench by way of the ballot. But I'm afraid that it is ingrained in our culture that we, even though we're judges and running for judge positions, that we are treated as if we're politicians, and we contribute to that problem. My approach has been not to seek out endorsements with the knowledge that after this is done, I'm going to be a judge either way.
You had a comment, Robyn Brody?
I think one of the issues that we potentially run into in the judiciary is that careful relationship between the judiciary and the legislature. You know, when we stand on the courthouse steps with the legislature, I'm not sure that we're sending the right messages to the people of the state of Idaho that there's a clear division between the judiciary and the legislative branch. We've got to, as a judiciary, be willing to stand up at times to fight for the people's rights in the state of Idaho when the legislative powers have overstepped those boundaries.
Clive Strong, would you like to respond to that?
Yes, I would, because I think it's important to recognize that we have three coordinate branches of government and we need to work with them all. And part of my career has been figuring out how to get those coordinate branches of government to work together. So to the extent that you're standing with a legislator, that isn't necessarily indicating that you're going to be partisan to that particular branch of government. In fact, my career demonstrates that when necessary, I've taken the action to bring to the legislature's attention a violation of the separation of powers. The Wasden versus Land Board case is an example of that.
Senator McKenzie, would you like to respond to that?
Well, I would just say that it's important in a role as a judge to apply the Constitution as it's written and apply that to laws that come before it. And I've tried to do that as a legislator when we were brought laws that appeared to be unconstitutional to me. Probably the biggest example recently is what is called the Ag-Gag bill. I debated against that, was one of the few Republicans to vote against that, and it was found unconstitutional in the federal courts. And so I think that mindset would serve us well on the bench as well.
A final comment on
Please.
that, and that is the judicial ethics speaks to not only creating actual conflicts of interest, but also the perception of conflict of interest, and that's important to note.
All right, the next question is going to come from Rebecca Boone for Judge Gutierrez.
Judge, I'd like to know how you, what your stance is on how to enforce the proper balance of powers between the judicial, legislative, and executive branches. For instance, should courts be able to strike down statutes that they feel jeopardize the balance of powers, or is it best left as a self-equalizing branch of government that everybody just...
Well, obviously the separation of powers dictates who has authority to act in what fashion. And in terms of the court's role as it relates to the executive branch and the legislative branch, is that if there are statutes or acts which are unconstitutional, at that time the court then can step in.
As a follow-up, how much autonomy should judges have when it comes to that sort of decision making? Should judges ever take policy goals, ideals, or public opinion into account when making rulings?
Oh, absolutely not. The judge's role is to only consider the law and apply that law to the specific facts of a case.
I'd like to have you answer the same question, Mrs. Brody. How much autonomy do you feel that judges should have, and how do you protect the balance of powers?
I think it's imperative that the people of the state of Idaho know that they have an independent judiciary. I agree that in a small state like Idaho, it's important that our judiciary and our legislature at times work together on issues related specifically to the justice system and how we administer it in Idaho. But when it comes to making decisions, when reviewing legislation, when reviewing issues about fundamental rights, I think the people of Idaho deserve to know that they have an independent judiciary who isn't subject to the whims or the tide of public opinion or political influence. We have to be a separate and fiercely independent branch in order to protect the people of Idaho.
Mr. Strong, on the same topic, I'd like to hear what you think about the balance of powers and judicial autonomy, and whether policy goals or ideals should ever be taken into account. And specifically, I'd like to know your thoughts on, since you've been involved in so very many natural resource cases as a litigator, will that impact or affect the way you make rulings should you be elected to the Supreme Court on those issues?
Well, I'd first like to address the issue about separation of powers. That's an area in which I've practiced extensively, and there is no role for the judiciary to inject its own policy or personal interest into that particular outcome. The role of the judiciary is to interpret the law as written and to look to the authorities that are given to the respective branches of government. And to the extent that a branch of government steps over those boundaries, then it's for the judiciary to call balls and strikes. I've had two instances where I've had to do that. One is the Wasden versus Land Board case, where the legislature attempted to invade the prerogatives of the Land Board. We had to sue the legislature, and we were successful in defending against that encroachment. And then in the Snake River Basin adjudication, we also had an issue between the judiciary and the legislature as to the respective roles that I had to litigate. As far as my background in natural resources, that should not have any influence in any of the outcomes. I will, as a judge, look to the rule of law and apply it as written.
Senator McKenzie, I'd like to have you address the same topic, and I'm particularly interested in your take on the balance of powers. As a lawmaker, you have occasionally voted in favor of proposed legislation after the legislature has been advised that it would overstep some constitutional boundaries. And so how do you reconcile that with what your role would be as a judge?
I think that question gets to a very fundamental philosophy of how a justice interprets the Constitution. In one camp is that the majority will establishes what the rights are from the government, so that we form the government and the majority determines what the rights are. I think this approach leads to what people call a living document of a Constitution, where the prevailing majority will determines what those rights are. In the contrary camp is the idea that we have certain inalienable rights that exist separate and outside the government, and that those can't be taken away, and those are reflected in the Constitution. And so if there are unconstitutional statutes, then it's the role of the courts to strike that down. I've tried to practice the same philosophy as a legislator, We get advice on both sides of bills all the time. We have to make a decision, yes or no. I've tried to err on the side of supporting only things that are within the constitutional bounds.
Judge Gutierrez, I have a follow-up question for you. So the three other people running for this seat have been practicing attorneys for a very long time, whereas you've been in the judiciary since 1993. So is it a little bit easier for you to take the high road on this because you don't have as many apparent conflicts of interest?
You might say that in part, but also the way that I've conducted myself in avoiding conflicts of interest has been a major emphasis in the way that I've have led my career on a professional level.
All right, the next question is for Judge Gutierrez from Bill Denser.
Good evening, Judge. Good evening, candidates. My question is about the ruling in the case of James versus City of Boise. In January, unanimous Supreme Court summarily reversed the Idaho Supreme Court in that case. Idaho court had maintained that it was not bound by the higher court's ruling in how attorney's fees are awarded to a plaintiff, to a prevailing party in a federal claim. So the principle in question there is about whether states are or are not bound by federal court. And I wanted to hear your views on that and also open that up to the other candidates.
Well, I think if it's within the purview of the federal authority, that we're bound by it. If not, if it's a state right and an action that pertains to state law, not involving federal authority, then I think it's appropriate to disregard that.
Okay, how about go down the line if we could, Senator McKenzie?
Again, one of the limitations we have is we're not able to speak on issues that could reasonably come before the court. So I think I can speak generally about federalism.
That's fine. That's exactly what I'm looking at.
And so again, if it's within the federal purview of a case within that system, then awards can be made. Otherwise, it would be beyond the authority of that court.
Okay.
I would agree that when there's the authority is in the Supreme Court or in the federal Constitution, and that's been interpreted, then the state law or state courts are bound by those interpretations. But if it's a matter within the prerogative of the state, it's appropriate for the state court to rule upon that.
Okay.
Actually, I had a unique opportunity to ask the court to allow me on behalf of an organization to actually appear in an amicus capacity in that case to talk to the court about the ruling. I believe absolutely in the division of powers between the states and the federal government, and any time that the states' rights are invaded, that's a problem. But it's also important to recognize that there are boundaries to that, and in the James case, we had a Supreme Court of the United States opinion interpreting a federal law, and it was the supreme law of the land, and it was an instance where the court overstepped its boundary.
Based on that last answer, do any of the other candidates want to kind of drill in a little bit more to the subject before I go on to a follow-up? Okay. I wanted to kind of contrast that to a similar dynamic, and this goes back to another state. And if you recall, after the Obergefell decision in the U.S. Supreme Court, Chief Justice in Alabama, Roy Moore, initially refused to or defied the court in that ruling. Is that appropriate behavior for an elected official, for a court officer rather? And we'll start with
Judge Gutierrez.
Judge Roy Moore. He refused to be bound by the decision in the Obergefell case, which was the same-sex marriage case.
Yeah. Yes. I think if you cannot, as a judge, follow the law, then I think you need to take off the robe.
Okay. All right, the next question is going to come from Rebecca Boone on diversity, and it's going to go to Robyn Brody.
Mrs. Brody, multiple studies have shown that having a woman or person of color on a judicial panel doesn't just change the rulings that come from that particular panel, or from that particular seat rather, but it changes the types of rulings that come from the entire panel. In other words, these studies have shown that diversity changes both the deliberative process and the subsequent rulings that come from a panel court. A study in 2012 showed that about 11% of Idaho's judges were women, which is the lowest percentage nationwide. With that in mind, do you think plaintiffs, particularly women or minorities, have been given short shrift by Idaho's courts?
I'll tell you what, we would have a lot better decision making in our courts with a judiciary that looks and reflects like our communities. I have no doubt in my mind. I know in my own practice, when I work with men and other folks, I'm a better lawyer, we make better decisions, we get better results for our clients. There is no doubt in my mind that we need to make a real concerted effort when we have qualified, capable people in the judiciary who can take on these roles. It's imperative for us as a state to take action and help put us in positions of leadership.
Please go ahead. We're going to go to Clive Strong first, but you'll have your chance to answer.
Thank you.
With that diversity and diversity in mind when it comes to judicial panels, what do you think about the diversity on Idaho's courts, and do you think your own experiences within your gender or cultural upbringing should or would have any impact on decisions you might make as a justice?
I think ethnic diversity and cultural diversity on the court is imperative. I think it's something we support, but it's not just on the court, it's throughout our entire practice. And it's something that I take into account as a supervisor within the Office of the Attorney General. I have many very well experienced attorneys, female attorneys that work within my office, many of whom I've supported as they've gone on to the bench, both as magistrates and district courts. I also have done a program of trying to foster the advancement of women within the office. I had a legal secretary, for example, that I perceived had the skills to be an attorney. I encouraged her to go to law school, and she's now working for me.
Senator McKenzie, your thoughts on diversity within the courts?
Well, I think it's important, not just diversity, gender and cultural, but backgrounds of people who serve on the court. One of the roles of our Supreme Court is to administer our court system and to develop those district judge and magistrate judge and other judges that reflect their communities, and that's something that we can continue to work on.
Judge Gutierrez.
Judge Gutierrez, I think you recently related an incident to Betsy about court interpreters and how your experience as a minority on the court actually allowed you to identify a problem within the court system and that some of the interpretations weren't being correct. What can you tell me about your thoughts on diversity within the court and whether that plays a crucial role that should be fostered or not?
Yeah, I think it is vital, not only in the deliberative and the decision-making process, but in two other areas as well. One is in the administration of our court system and how we develop policies and programs that impact the entire citizenry. And third is the fact that I believe it adds authenticity to the court and what it stands for, and that is justice for all.
Rebecca, you had a follow-up?
I did, yes. So what do you think is the most important aspect of representing the state in the courts that we're currently missing? I mean, what do we need to do to increase diversity?
Well, we found out through the judicial recruitment and retention survey or report that we were operating under a perception by the bar that folks were disqualifying themselves from applying to the bench. That included women and minorities. And so we need to work on eliminating those barriers, those perceptions, and also doing more on the recruitment end to have a proactive Supreme Court on that issue. We have with the diversity section a pipeline program, and it's geared towards disadvantaged high school kids, and starting early, hoping to create a pipeline so that we can diversify both the bar and the bench.
Mr. Strong, you talked about diversity of practice and also people within your practice. Does that have the same, does hiring, say, clerks who are minorities or women have the same sort of impact that having a broader representation within the judiciary itself?
Well, I think it's important to have a broader representation within the judiciary, but you have to build from the bottom up, and so that's what we're doing. Is every one of us has an obligation to try to foster that type of environment, and that would be what I'd try to foster on the court, is an environment that would invite that kind of inclusive participation from people of all backgrounds and experience.
All right, the next question is from Betsy Russell.
Can I finish out with a comment?
Actually, please do.
And that is, I don't know that it's obvious to folks in the TV audience that, in fact, the Supreme Court in Idaho is one of 2 or 3 courts in the country that doesn't have any gender representation or people of color representation.
All right, next question from Betsy Russell.
This question is for Mrs. Brody. You're the only candidate among these 4 who's come into the race without a significant background in government. Should voters consider that a pro or a con, and why?
Well, probably my only significant background in government would be suing the government. From my world, I view it as a plus. When I talked about in the beginning about crawling into the foxhole with the people of the state of Idaho, that's exactly where I'm coming from. Don't get me wrong, I'm not a contrarian, and I'm not somebody who's just all about saying no. I'm all about saying yes and providing people with access and basic rights. I guess from my perspective, even taking on this race, I viewed this as a chance to vote with the people. I'd put my trust in the people every single day of the week.
And Mr. Strong, your background in government is quite extensive. What does that mean as you approach the role of an Idaho Supreme Court Justice?
Well, I think I bring something unique to the Idaho Supreme Court with my governmental experience. I understand how the legislature and the executive branch and the judiciary interact. I've dealt with those conflicts, and I understand how they can arise and how to prevent them as you go forward. I also understand the administrative law process. That's becoming a much more significant aspect of the judicial practice now, and there is nobody on the court with that background in administrative law that could come forward and provide that background and experience to the court. So I think my governmental service is actually something that is needed on the court.
You know, before we move on to Senator McKenzie, I have a question for you, Mr. Strong. Okay. And we kind of touched on it earlier, but you have worked in the Attorney General's office for 30 years now, since 1983, and you have worked with many of the people who end up representing the state in front of the Idaho Supreme Court. So will you be willing to look at those impartially, or will you have to recuse yourself from everything that the Idaho Attorney General's office has touched?
I think if you look at my career, the answer is there. When the government exceeds its boundaries, I've been willing to take on that case and argue it. Again, coming back to the Wasden versus Land Board case, when the legislature and the land board exceeded their authorities, I prosecuted those cases. When there was a conflict between the judiciary and the legislature, I prosecuted that case. So I think my record demonstrates that when necessary, I am willing to take the steps to make sure that the coordinate branches of government comply with the law. And in advising agencies, I do the same thing. I advise the agencies when they're exceeding their authorities.
Robyn Brody, you wanted to...
I just wanted to address that issue. I think there are cases that my opponent's been involved in extensively, and where it's not just a matter of being in the office where those cases have been handled, but I'm talking about real, intimate, day-to-day involvement, and those disputes are likely to percolate up through the system.
Well, but one of the clients that you've represented, Mrs. Brody, has been Rankin Water, which has had 2 recent cases in front of the Idaho Supreme Court. So if they show up again, will you be able to remove yourself from that, or will you have to recuse yourself, or will you be able to look at those water issues impartially?
Oh, no, I would have to recuse myself from any issue involving my client, any issue at all.
The next question for Senator McKenzie.
Senator McKenzie, your background in government has been in the legislative branch. For 7 terms, 14 years, you've been a member of a different branch of government that did not always agree with the judicial branch. How do you bring that experience to a position as a Supreme Court Justice?
Thank you. You know, I think it's a useful background to have, to be both one of the longest serving state senators as well as having an active practice in the law while I was doing that. We've had other justices with that background. Justice McDevitt was in the legislature. Justice Jones was an elected attorney general. And I think those types of background help inform your decisions and understand the clear distinction between the different branches. And so I think it's a good background to have, and certainly helps me understand how our laws get to the court. Just like having a trial practice helps me understand the way that evidentiary issues arise and come before the court.
And Judge Gutierrez, your governmental experience, by contrast, has been in the judicial branch.
Yes.
For many years. So how, as a Supreme Court justice, would you approach the executive and legislative branches?
Well, with much respect, as we are all equal branches of government, but also with the idea that some problems are not best resolved by lawsuits or cases, but rather by working together. And to that extent, I would do my work as a justice in deciding cases, but also be looking to participate in collaborative working towards solutions. I would also say that my background as a lawyer also includes administrative practice of law, and also say that one of the benefits from being a judge this many years is that I've been able to see the change in our court system, and where we operate much differently today than we did in 1983.
You talked about the different branches of government working together. What are some examples of how they can do that, and is that appropriate?
Well, yeah, it is. It is. I was a member of the Governor's Criminal Justice Commission as a Court of Appeals judge, and one of the actions that we took was to bring in an outside group to evaluate our public defender system. That is an extremely important area to address as we talk about access issues. I think it was Justice Breyer who mentioned in the Luis versus United States case that only 27% of our county-funded public defenders programs in the country are really operating as they should. So with the work in the Criminal Justice Commission, that's an example of how that can be achieved.
All right, the next question is from Bill Denser.
And this is to, I'm sorry.
For Robyn Brody.
Mr. Brody, thanks. Whoever wins this seat is going to be one of the state's top judicial officers and therefore an advocate for the entire judiciary in the state. I'm curious to hear from you and then from the rest of the candidates what some of the challenges are that face the Idaho judiciary over the next decade. Are there enough judges? Are they paid enough? Is the system working well? Is it overburdened? What needs to be addressed?
Well, absolutely. The number of judges, actually the turnover of judges is going to be an incredible issue that we face. I believe it's nearly 50% of the judges are going to be eligible for retirement over the next 5 years. Frankly, I'm hoping that me jumping into this race maybe will give some others the desire to maybe want to jump into the judiciary and maybe the notion that it's possible, that it's doable. The other very big task that the judiciary faces is implementing technology throughout the state. We're working on it in Twin Falls County, and we've got 43 more counties to go, and that's going to be an enormous undertaking.
The next question is for Clive Strong.
Okay. I believe that the biggest issue confronting the court is access to the court, and access in a number of different ways. One is simply access to the information that comes through the court. We're in the process, as Mrs. Brody said, of trying to implement an imaging system and a case management system. Those are things I implemented over 20 years ago in the Snake River Basin adjudication. So I have experience in dealing specifically with that kind of management experience and also case management experience. The other type of access is just the cost and time of pursuing a case before the court. We're seeing a decline in our number of civil filings, and I think a large part of that is because we haven't tailored the system to the needs of the individuals. We need to figure out a way to make access more affordable and timely for the individuals. And likewise, on the criminal justice side, what we're seeing is a lot of delays in terms of being able to get responses back out in some of the cases. And so some of the diversion courts, like the domestic violence court, are providing ways to specifically address some of those time delays on the criminal side. And there's others that are going forward, but just some of those are things to think about.
Thank you.
Senator McKenzie.
Thank you. It's kind of an exciting time for Idaho with our justice system, because we're going through some significant changes to the public defense system. The biggest change in decades in the state, in the way that we ensure that people are properly protected when they go through the court systems, even if they're indigent. Over the last couple decades, we've had our problem-solving courts. I've spent hours in problem-solving courts with clients in mental health court, drug court, veterans court. That's a very different way of how people interact with our court system, and it's very important. And so that's something we're going to need to keep working on. And then the other issue that we've touched on earlier is judicial recruitment. To continue to get good candidates that reflect their communities and ensure our judges don't have caseloads that make it so that justice is delayed for people.
Judge Gutierrez.
Yes, I think, as always, resources is a major issue confronted by the justice system in Idaho. To give you an example, since I came, since 1993, while we've added judges, we have not yet added any additional staff to the clerk's office at the Supreme Court, and increasing caseloads all the time. Another example is with the increasing diversity in the state demographically. Ada County, for example, for the last few years has been averaging about 50 different languages needed, different languages for our court to operate and provide those individuals who need interpreters. It is a very high cost. The other area that I see is on the access issue. We talked about the public defender system, but also on the civil side, and it is a problem across the country, the declining of civil justice. There's part of it is the cost of increase in litigation. You would ask a young lawyer if he could afford to litigate a certain case of his own, and the answer would probably say no, he could not. We see an increase in pro se litigants, and that indicates that folks are having to turn elsewhere, not being able to come to our courts to get their conflicts and their claims resolved.
Judge Gutierrez, I have a follow-up question for you. So you touched on access to justice, the public defense system. The state of Idaho is currently being sued over its public defense system, and you've been a member of the judiciary in Idaho since 1993. How much responsibility does the judiciary have for the state of Idaho's public defense system?
Well, I think that it's important because it's the judge's role to ensure that the Constitution and the rights that are given defendants are protected. And so we have to act. Whether somebody else has other responsibilities, the courts have to act. And so from a trial judge's perspective and my view of a lawyer who is not performing, I would have to take action in that regard.
And Senator McKenzie, I'm hoping to get your thoughts on that too.
Well, this touches on the issue that Betsy asked earlier about the interaction between the judicial branch and the legislative branch. Sergio said the judges can try to ensure that rights are protected, but that takes funding. And it takes standards for contracts, which we didn't have for decades in the state. I've served on the Public Defense Interim Committee for the last couple years. Now we have standards for what's in public defense contracts, and now we've got state funding to help the counties cover that cost. And so it is an important issue, and it's one of those that the two branches have to work together in order to solve it.
Why did it take so long?
You know, that's a good question. We were a state that was very early on recognized the right for people to have a public defender. It was always provided at the county level, and it was that lawsuit that was mentioned that brought it to the attention of the state and got the action in order to move forward.
All right, the next question is from Rebecca Boone to Clive Strong.
Judge Gutierrez touched on this a bit, but I'd like to get your thoughts on this. What role do you think pro bono work should play in the Idaho judicial system? Idaho Legal Aid has frequently said that they're struggling for funding. You know, the attorneys are expected to do a certain amount of pro bono work generally. Do you think that's enough to handle the state's civil litigation needs?
Well, as a profession, we have an obligation to help serve the public, and so I'm very much committed to the idea of pro bono work, and I think it's something that the bar has attempted to encourage in a significant way. Whether we need more, I'm not sure I'm in a position to evaluate that today, but it is something I think we need to look at and I think we need to foster.
And Robyn Brody, please.
You know, was recently at a candidate forum, and Dennis Voorhees, a former bar commissioner, actually raised the issue about whether we need a mechanism or a way for non-lawyers to be able to provide legal services to folks. And you know, I think that's something that we've definitely got to explore. The reality is this, and especially like in places where I live in Rupert, people don't have access to basic things like internet services, being able to fax a basic letter to the Unemployment Commission or to Health and Welfare. And it is, and I know lawyers are out there doing the same things that I know my friends are doing, which is we open up our doors and we help in any way that we can, but it's never enough. And I think the bar as a whole has got to look at creative ways at providing people with access to the law.
Mrs. Strong, do you think that attorneys should be required to do pro bono work? Or you mentioned having individuals who aren't attorneys perhaps take on some of this role. Does that create a kind of a lower tier of less effective representation then? Well,
I've seen incredibly effective representation from non-lawyers, particularly, for example, in the Social Security system. I agree that it's a very difficult balance to strike. That is, you know, how do you make sure that you've got competent, capable people helping? I don't know what the answer is. I know this. Generally speaking, creating a policy or a rule, putting a number saying, you know, a lawyer has to provide so many hours of pro bono service every year. I don't think that gets us anywhere towards what we're really talking about, which is helping people with fundamental access to the courts. And I think it's bigger than just a pro bono issue for lawyers.
If I may comment.
Briefly, and then we...
Yes, yes. I think it has to be addressed by three groups, and that is the courts, the lawyers, and also the law schools. And we see some of that work being done by way of clinics in the law schools. And on the question of paraprofessionals, other states are beginning to do that, focusing on certain areas of the law, such as for family law purposes. And I think that's the multiple approach is the best way to go.
Senator McKenzie, did you?
Well, just to get back to the issue of the pro bono work, you know, we now have 2 law schools in kind of the population center of the state. When I was at Georgetown, one of the things they did very well was clinic programs, and I think we will start to see those students both get experience themselves and benefit the community through their legal service as we expand those clinic programs.
You wanted to weigh in,
Just
Mr. Strong?
one quick thought. One approach to doing that is through an incentive-based approach in the Office of the Attorney General. What we do for pro bono is we make an opportunity for people on the staff to conduct pro bono work as part of our service to the public. And I think if we could do the same thing in other firms, that would be a way to start incentivizing people to participate in the pro bono program.
The next question is from Betsy Russell for Senator McKenzie.
Senator McKenzie, one long-standing tension within our court system is transparency versus privacy. Where do you stand on electronic documents and the public's access to them, as well as cameras in the courtroom?
Thank you. Well, first, the issue of access and electronic documents. I think our federal courts is a great example for us to move towards, where everyth's filed electronically, and it's very easy to access those in PDF form, both for litigants and then people who want to see those public documents. On the issue of cameras in the courtroom, I think the overriding issue of transparency is important. There may be cases where it's inappropriate, some juvenile cases where there's sealed information, things like that, but the overall principle should be openness in the courtroom.
Right, the next one is for Clive Strong, and if you could please address the same thing.
Same question.
Okay.
Cameras in the courtroom, electronic access to documents.
I think this is an area where our courts have done a very good job. They have a media and the courts committee that has worked together to develop a manual that helps the media understand the relationship between the court and the media. We have rules in place that openly embrace the idea of cameras in the courtroom. Having cameras in the courtroom creates trust amongst the public, and there's protections provided in those rules that allow the judge, if necessary, to put limits on the camera in the courtroom in order to protect the individual rights. So I think we've really done a good job in that area.
The next question's for Robyn Brody. Same question.
Same question.
I don't, Betsy, I think the answers that have been given are the ones that would come from me as well. I mean, I think just balancing access and openness in the courts with fundamental rights is important, and I think the media guide goes a long ways toward doing that. And
Judge Gutierrez, any thoughts on that?
Yes, I think it's great that we move further in that direction. And I appreciate the fact that Supreme Court now is having those oral arguments televised. Now we just need to get the Court of Appeals in there as well. But I would mention that one of the other things that is important, two things, is the fact that I think would be helpful to judges. We know we have to balance access, but that it's important that judges realize that we are accountable in the work that we do. And second, that I think we create a more informed citizenry.
The next question is from Rebecca Boone to Clive Strong.
Mr. Strong, when someone is on a panel of judges, they have to obviously work very closely with their peers on that panel. I'd like to hear about your process for decision making, or what your decision making process would be. Obviously, you'd read the briefs, hear the arguments, look at the case law, but how would you approach that from a group's dynamic?
I would approach it the way I've approached my practice. Over the last 30 years, I've been involved in some of the most significant settlement cases in the state of Idaho that have resolved decade-long controversies. And the way I approach that is to sit down and listen to all the parties, get their perspectives, their views, and try to find a way that we can find common ground. On the Supreme Court, I would approach it in the same way, in the sense that respecting the fact that there are 5 justices, all who have their own independent views. We ought to be able to talk through the issues, openly discuss them. If we agree, we ought to be able to disagree and do it agreeably. And that's the policy I've always followed in my practice, is you ought to be able to disagree but do it in an agreeable fashion.
Senator McKenzie, you can respond.
Thank you. And I'd say similar. Obviously, you need to be true to your view of the facts and law before you. Try to reach consensus on the issues that you can. If you need to do a separate concurrence or a dissent, obviously you do that. But working together, try to do so in a collegial manner. I try to separate personalities from issues. I don't think it's appropriate to name call either other justices or call out people who come before the court. You know, one of the justices I've always admired from his intelligence and philosophy, Justice Scalia, is not necessarily someone who I would follow in his questioning of people, because he had a very sharp wit.
And we're almost out of time. If Robyn Brody could respond, and then Judge Gutierrez very briefly.
I think you just have to be an excellent student. You know, when you start out a new job or a new endeavor with anything, the first thing you've got to do is take stock of how things work and the people, and learn. And from there, you can really start to influence, I think, and have a leading role in the decision making.
And Judge Gutierrez,
I think it's important to establish good, healthy relationships among the justices. And a good example of that is seeing the relationship between Justice Ginsburg and Justice Scalia, who have very close relationships, but many times they're on opposite sides. But I believe that they respect one another when it comes to the intellectual honesty involved.
All right, it is time for closing remarks. That hour flew by quickly, didn't it? It was a lot of fun. All right, Robyn Brody, if you could please give your closing remarks, and you'll have 60 seconds.
The best part of this campaign is that I have been all over the state. I've had the chance to go to places I never would have ever otherwise gone to. I've met people I never otherwise would have met. I've been from Port Hill up at the Canadian border over to St. Anthony. And I can tell you that the people of Idaho want the same things in a judiciary. They want open and accessible courts, and they want justices and judges who apply the law fairly and consistently. I would love the opportunity to serve on the Idaho Supreme Court. I know that when men and women work together, that we make better decisions, we get better results for our clients, we're better able to serve the people of the state of Idaho. I want to thank the League of Women Voters of Idaho, Boise State University, the Idaho Press Club, and Idaho Public Television for helping to educate Idaho voters and help all of us understand the vital role of the Supreme Court today. I would appreciate your vote on May 17th.
All right, thanks so much. Clive Strong.
I would also like to thank the League of Women Voters, the Idaho Press Club, the Idaho Public Television, and BSU for providing this forum so that we can talk to the voters. The election that's coming forward is going to be an important election. During the next 6 years, the Idaho Supreme Court is going to be called upon to decide serious and complicated constitutional and water law issues that will affect the lives of all Idahoans. My experience in these areas will be invaluable in deciding those disputes. With my statewide practice experience, I will be able to bring to the court an understanding and appreciation of the cultural, economic, and geographic differences that exist in Idaho. I understand the issues that both unite and divide Idaho. I look forward to fostering an inclusive environment before the court. My duty as a justice of the court will be to interpret the law, not make the law. I will not allow my personal or political preferences to influence any decisions and will be accountable only to the people of Idaho. My record shows that I will stand firm in deciding and defending the Constitution and laws of the state of Idaho, regardless of the political consequences that may follow. My campaign is based upon grassroots support, and I would appreciate your support as we go forward, and your vote on May 17th.
Thank you. Curt McKenzie.
Thank you. I think I bring a unique background of a strong academic foundation, a long history of public service, and a diverse legal practice. But more than that, I bring a love of the state of Idaho. I came here for college to play soccer and to run track. I stayed here because this is where I wanted my family to be. And now I've got the opportunity to serve on the court. I'm not running again for the Senate. I've given that up. And now I not only want to serve as the decision-making body of the court, but to administer the court system. I've been at the trial court level. I've been before the magistrates, the district judges. That's where most of the people who are going to interact with the courts appear. I know how important it is for them to feel like it is fair and impartial, and I'll work for that. Thank you.
Judge Gutierrez.
Thank you to all those responsible for making this possible. I think it's important to note to those in TV audience that in the May primary, we could have someone selected to fill this position if you get 50% plus one of the votes. In terms of my view of what's critical, I think it's experience. And I bring a unique personal experience, having been an immigrant, a high school dropout, and yet facing many challenges, being able to rise to the second highest court in our state. Also, because I've been a judge for quite a few years, I think I'm pretty well tested. You know what you're going to get. There's no guessing. So I would ask you to vote for me on May 17th.
All right, that's all the time we have for tonight. Thanks so much for watching, and we'll see you at the polls.
The Idaho Debates is a collaborative project of the Idaho Press Club, the League of Women Voters of Idaho, Boise State University's School of Public Service, and Idaho Public Television. The Idaho Debates are brought to you by contributions to the Idaho Public Television Endowment